policies were current and up to date for elections and other requirements moving forward when they were improved.
Comment?
Go.
Since you're talking about me, there is, the bylaws as such are solid on whether you have to bring your deal. I have here a copy of a ballot from 2010, and at the bottom it says, forms must be returned in person to the CLCCA office, along with the $20 filing fee. I have here copies of Mr. LeBlanc's application, and at the bottom it says, form must be returned to CLCCA office, and gives the address.
Okay.
So, to me, what caused this whole problem is not somebody trying to cheat the system. It's somebody in the office that doesn't know what the hell they're doing.
Well, that form actually is the 2011 form. The date at the top is incorrect.
Well, I don't care, it's 2011, it's not this year.
But the 2012 form was copied from the 2011 form, except it left off that information that you read for the 2013 form. The general manager used the boilerplate of 2012 for the 2013 election. The same trustees, or the two trustees and general manager who was here for the 2011 were also here for the 2012 and failed to put that information on there. Nonetheless, it was a resolution of the board that we followed.
But it says up here, deadline for filing to be on the printed ballot April 18, 2013. This was filed 4/17/13, which if somebody had told me that it was an invalid thing, we could have fixed it by the next day.
But did you not preside over the meeting that required?
I have no idea what I presided over. There's so much stuff that comes through here. Maybe you can remember all of it, but I can't.
Well, the election code 1.007 specifies filing in person or with an affidavit. So we followed the Texas election code as what our clarification, 68 clarification document, and what bylaw 4.1 stipulated.
Okay, but bylaws also matter. And if you can't get the bylaws straight, then.
And I agree with that. The bylaws are not good.
Right.
Comment, Fred?
Yes?
If you want to be on the board, you say you can't remember. These citizens want you to remember. That's your job. You're up here to
No, actually,
take care
my job
of
is
business.
working for the
If
special.
you can't remember this, Banks, you need to write it down because it's in the Texas code, it's in our law of
I must say, I
corporation.
have not ever read the election.
Then
code.
you're qualified for the position. Simple.
That's fine with me.
Because you're the one that wrote the law.
So why are we going against the Texas court system, which
Mr.
says,
Baggett, you have the same
Okay,
issue.
wait a minute.
I would sit there and not say a word right now.
Okay.
I'm going
Okay.
to make my
Wait,
comment
wait,
now,
wait.
since
Wait a minute,
everybody else
wait,
is
wait.
making comments.
Wait. One at a time, please. Okay. Are you done, Mr. Morrison?
I'm done.
Okay, Mr. Daggett.
Texas court system, when regards to elections, says that unless the offending thing that would cause the voters to change and vote differently, then the vote counts. So in this case, the fact that somebody didn't show up, in my opinion, has nothing to do with the fact that the people would have voted the way they voted. So therefore, the vote should have stayed.
Well,
That's part, if you're so much hardcore on the Texas system, that is part of the Texas justice system.
but the Texas election code specifies you apply in person. So the application was,
But you
invalidated.
You invalidated the election based upon that. The
No, we didn't
election
invalidate
should have
the
been
election.
invalidated unless the offense, which is not showing up in person, would have affected the other votes. And it didn't,
Obviously
it
it
wouldn't
did.
have.
Okay, is there any other comments from the board?
Yeah, I got one more comment.
Okay.
I would like to submit this to you, Fred. It says this letter shall serve as notice of my resignation as a trustee from the Board of Trustees, effective immediately. And for the people out here, I'm tired of this. I've listened to it for 3 years. I don't need any more stress in my life. I've got some health things I have to deal with. Plus, I got some trips I want to take. And I'm just tired of it. Now, I'll tell you guys this. Think about what you're doing. You're playing petty politics, and you laugh.
I'm laughing. We're following the code of ethics, we're following the code of Texas law. Did you follow it when you were in? Mr. Banks, we accept your, I don't want to get into an argument.
No, you
This is
can't
not-
accept it. No,
this is-
no, you cannot accept it until
I'm
he's
just,
got,
we're
he's
just gonna
got to
accept
do
it as
something.
is.
Roberta didn't do that with Chris Holder, so technically he's still on the board. There is a bylaw thing you have to do that I did know about. Okay, I'd like you to not make a comment, because what I'm going to comment on is one thing that we've been promised is a forensic audit. I don't remember ever seeing the results of a forensic audit.
Because it never came to the board.
In which case, I'm going to ask the district attorney to put a team on to make the forensic audit.
It's already in process.
It is.
Well, we filed it with the attorney.
Oops.
With no emotion.
Oops is right.
You should have known that.
Fred,
Wow. You're on the board, you should know that.
Say bye.
Oh, I know, you can't know everything.
We had an accountant that stole money, and I've never heard that any charges were filed against her.
Well, I can tell you that they were filed against her.
They were?
Yes, they were, and she is being prosecuted for,
Maybe larger than me.
No, it's on the agenda too, to make it public in the paper.
Oh, okay, sorry, I didn't know that. But, you know, just remember that you guys, you 8 people, sorry, are not here to do what you think's right. It's what you think is right for the association and the neighbors. That's what you're here for. You may be elected from Oak Brook or Oak Brook West, but you represent the entire association. And that's where your loyalty should lie.
Well,
And I'd like to say it's been
I wish
a trip.
I'd like to thank you for your prior service, no matter what our disagreements were in the past.
Well,
And I accept your resignation.
well, yeah, but you can't do that. You still got bylaws things you have to do.
Okay, under bylaw 4.2, within, it says the office held by a member of the Board of Trustees shall be deemed vacant upon the death of the trustee or upon the receipt of a letter of resignation by the trustee. No oral statement. Resignation shall be accepted within 5 days of the receipt. The notice such death or resignation, the president shall notify the Board of Trustees that a vacancy has occurred and provided them with a copy of the letter of resignation. So you should be seeing this in your email, or if Becky will make copies of it later on during break, we will satisfy that requirement. And I sincerely thank you for past performance. I don't hold,
Well,
I just,
I've got other things to do too. I know as long as I'm a board member, I can't bring suit against anybody, which I'm planning on bringing at least 2 lawsuits against members of the board. And if Mr. Borson says that forensic audit's going on, then I'll trust him on that.
I'll have to talk with him because I'm not familiar with that as of yet.
You gonna take your name tag?
Take your name tag. We got 2 of them.
Ah, yes, sir.
Hey, won't have to worry about knowing who you are.
Everybody knows their question.
Okay, comments from the audience. If there's no other comments from the board, are there? Yeah. Comments from the audience. The Texas state law prohibits the Board of Trustees from commenting on any statement, engaging in any dialogue within an appropriate agenda item, without an appropriate agenda item being posted in accordance with the Texas Open Meetings Act, Ethics Code 551042. Comments shall be limited to 2 minutes per person in accordance with policy 401-8 and directed to the entire board, not individual members. Engaging in verbal attacks or comment intended to insult, abuse, malign, or slander any individual shall cause for immediate termination of speaking privileges and directed to be seated or expulsion from the board meeting. I'm hoping not to ever do that. As appropriate, trustees may respond per government code construction 311016, but are not obligated to respond to an inquiry even if listed on the agenda, but may choose to remain silent or to identify the policy or procedure applicable to the inquiry or to request placing the inquiry on future agenda. 2 people filled it out. First one is Howie Katz.
Ladies and gentlemen of the board, I've been a resident of Oak Brook since 1970. Recently, I found a note attached to my door. I found out later that it was attached to other doors too, saying that this board stole the votes of Oak Brook residents. Well, in my opinion, the board didn't steal anybody's vote. That election was hijacked by people who do not live in Oak Brook, who are not residents of Oak Brook, who haven't been residents of Oak Brook, who didn't even know the candidate that these people dug up. And the only people who know him, I certainly don't know him, I don't think he ever attended a board meeting, were his immediate neighbors. Apparently the gentleman did not bother to familiarize himself with the election rules. And the only reason, these people didn't vote for this gentleman, they voted against Roberta Toppin because before the election, people that did not live in Oak Brook went door to door bad-mouthing Roberta Toppin. So the people that voted for Mr. LeBlanc didn't really vote for him, they voted against Roberta Toppin because of the way she was smeared by the people who dug him up in the first place. So I think you did the right thing. If his application wasn't admissible, then the election was never held. And his vote should not have been counted.
Okay. Next is Judy Tuck.
Yeah, do you mind if I stay seated, sir? Or do you want me to stand, or?
No, you can stay seated.
Okay. Well, ladies and gentlemen, I'm a new resident here in this community, and apparently it's pretty prevalent with what they call community development organizations, 501c corporations, that basically, we don't know what, the agendas are. We can't look under rocks that are cemented, that type thing. But if you really want to get down to the meat of the matter, you could demand an audit to know where every penny has gone, and you can ask for minutes of any of the past meetings. I understand, I'm disappointed because I really wanted to meet Roberta. Everybody and their brother's been coming to my door at my house talking about how wonderful Roberta is. I'd like to meet her, keep an open mind. But once that the audit is done, if there is any malfeasance issues, I did call the Secretary of State's office, the state of Texas, and you can call them too. It's up in Austin. And once the audit takes place, and if there's any malfeasance issues, the IRS will come in. They will take away the designation, and there'll be some, heads rolling, from what I'm understanding, talking with some people. So, it's up to y'all. I'm new. I want to stay here, and leave, my properties. I want to buy multiple properties. I've got 2 so far in the subdivision, and I want to leave them to my relatives for future generations, because I think this is a beautiful place. And I know you guys didn't take this job, as though it was a luxurious thing to do, and that y'all are driving Mercedes-Benz and, living high on the hog. But, I really appreciate that you've got a little democracy to allow me the ability to introduce myself, and I wish you guys all the best with what's going to be coming down the pipe.
Time.
Thank you.
We need to take a short recess. This recorder is full and it's not recording anymore. You need to dump it.
Okay, it's all about.
just to answer your question, from April 2008 through March 2013, the minutes are on the website. And the agendas from June 2009, I think, through present are on the website. But we're taking a short recess while we can dump the recording.